everyone, I'm Danielle Claffey, partner with Kuck, Baxter Immigration here in Atlanta. And today I'm real quickly going to talk about something called the 336B action. And the reason I want to talk about this briefly is because I just went over mandamus actions. Again, which as I said is a way to challenge cases and get a decision for a long pending application in court. But what I've specified is a 336B action, which is just a section of the law. It's a way to actually challenge waiting on a long pending decision based on a naturalization application where the person has already attended their interview. So under federal law, there are two ways to challenge a delayed naturalization application. The mandamus is before interview. The 336B petition is after the interview. So by law, once somebody has been interviewed on their naturalization application, USCIS is obligated by law to issue a decision within 120 days after the interview. Once we've surpassed that 120 days and a person still does not have a decision, that's what brings us into the realm of being able to file a 336B petition. So again, it's filed in federal court just like a mandamus. It's filed via a complaint that we draft. They're called pleadings, where we include the whole history of the case. And again, just as importantly as mandamus actions, we have to make sure we vet it very carefully, because anything and everything will come up. Immigration history, everything always matters, nothing ever goes away. So that's why, particularly if we've not handled the case before, we have to go through it very carefully and make sure that the person is in fact eligible for naturalization, that nothing negative is going to come up, because our goal by going into federal court is not just to get a decision, but of course to get an approval and have somebody sworn in as a United States citizen. So again, these 336B petitions, once the complaint is filed in federal court, and then defendants are served, meaning the government agencies that are involved that we're suing, again, they have 60 days to respond back to us to let us know what they anticipate doing, how they anticipate handling this. So with respect to 336B petitions, I always like to explain to a client, look, I know you've been interviewed before, but it doesn't mean you may not be interviewed again. I see that a lot with naturalization because there's always a double check. They always go back and look again. They always run a naturalization by a supervisor before issuing a final approval and an oath ceremony notice. So a lot of times, invariably, within that 60-day period, again, the U.S. attorney will contact me, say, we're aware of the lawsuit, my clients are working on it, they want to schedule this person for another follow-up interview, or they want them to bring their latest tax returns or something employment related, or maybe there was some type of criminal charge or anything like that, to make sure that they have all the final documents they need. So that's what happens a lot of times. We have a follow-up interview, we get a decision, we get scheduled for the oath ceremony, and it's only then that I will agree on behalf of the client to actually dismiss the lawsuit, is once I know that that person is being scheduled and has taken their oath to become a United States citizen. So again, taking an action like this into federal court where you've been interviewed on naturalization and you're waiting, can be a very effective way to finally be able to acquire your U.S. citizenship. So if you have any questions, please go to www.immigration.net, check out the website, the links to 336B petitions, or feel free to give me a call or email me with any questions. Thank you.